And according to this, you have children. That's why I told you to do parenting classes.
Okay.
And it appears you haven't done anything since 2008. The document entitled Motion to Revoke Community Supervision and states motion to supplement pending motion to revoke probation with your attorney. And did you understand it?
Yes, ma'am.
Are you the same Adriana Tanahara who's placed on community supervision in 2017 CR 13698 for the offense of forgery of a commercial instrument or check on August 3rd, 2018 for a term of 4 years? Is that you? All right, state.
Violation of condition number 38. On or about the 25th day of August 2020 in Bexar County, Texas, the defendant, Adriana Tanahara, did then and there fail to participate in the felony drug court program in violation of condition number 38.
How do you plead to that? True or not true?
Not true.
State.
We waive and abandon the remainders.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility, and up to a $500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 38?
Yes, ma'am.
Court will find violation of condition number 38 true. Is there a proposed agreement?
Judge Astute is asking for revocation and a sentence of 1 year in the state jail facility.
And Judge, that is our agreement, if I may speak on behalf of my
Yes.
client. Ms. Tanahara was originally placed in the drug court program. She was having financial difficulties with participation. When she was removed from the drug court program, she started to have medical issues, congestive heart failure. I have some documentation of that congestive heart failure if you'd like to review that. As her medical condition got worse, she became more and more concerned about turning herself in because she wasn't going to get her medical treatment.
Mm-hmm.
She understands that this was not the appropriate way to handle this, and that because of that, she only can be either terminated, unsatisfied, or revoked. But she is here wanting to take responsibility, and I do think she wanted to address the court really quickly, if she may.
Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Adriana Tanahara.
All right, your attorney mentioned something about financing.
Yes, ma'am.
How was that related to drug court?
I was just unemployed. I wasn't applying myself as I should have been. And since then,
No. Because it seems as though
Mhm.
maybe a conversation that you've had, you're saying that you had issues with finances in felony drug court. And normally felony drug court does not require you to pay the $1,000 fee until you're closer to graduation. So I'm wondering, just so I'll know,
Mhm.
what finances are you saying you had difficulty with in felony drug court? Because they help you
No, I
with
didn't-
employment.
and not in the drug court. I had it in the program, I guess, that they offered me the last.
What program?
My probation officer had called me and told me that there was a program I could pay off my fees in a certain amount of months. And
What program?
I don't know what it was called.
So two things, Judge. How I was addressing the drug court was that she was not able to provide for herself, not provide for the drug court because of financial issues. So that's issue number one. And then issue number two is that according to my client, the felony probation officer told her that if she was able to just pay off her fees, they would terminate her from probation. I know that that's not necessarily the way that it works, but that's how it was discussed with her. And it's not the first time I've heard that being discussed with the client. So I think just for court's clarity, I think that's what she's speaking about.
Okay.
And let me give you the documentation on the medical.
And then my other question is, it said that you owed $743.99 to HEB. Has that been paid?
Yeah,
I'm sorry?
no, ma'am, not yet.
All right, you've had since 2018 to pay that. Why hasn't that been paid?
I wasn't always employed, but it was my fault.
But I mean, it's since 2018 and you haven't paid a penny to that? That's a problem.
Yes, ma'am.
And then this is not your first motion to revoke. That's a problem.
I understand.
So what have you done? Have you done anything other than this is your second motion to revoke?
I've just got employed. I mean, I've just, been fine.
I mean, if you haven't done anything, I mean, just tell me.
No, ma'am, I haven't done anything towards the courts. Correct.
Because you were placed on probation before I was presiding judge in this court. And then you had a motion to revoke, and it was violations of 5 and 5. And according to this, you have children. That's why I told you to do parenting classes.
Okay.
And it appears you haven't done anything since 2018.
Sorry.
I mean, I don't even know. Somebody explained to me why I should give you a year instead of 2 years because you haven't done anything.
I guess the basis of our request is the congenital heart failure and the medical treatment that you would receive in the state jail facility. She hasn't done anything towards the board, but she did at one point receive gainful employment, and that was a huge struggle and a huge hurdle that had to be overcome by Ms. Tanahara. I think you can see based on her drug court participation, as well as even the medical documentation, she is a methamphetamine addict and has struggled with addiction for quite some time. And so even just getting gainful employment was a feat in and of itself.
And who's taking care of your child?
I think it's her mom. Is that
That's my sister.
your sister? And they're here, Judge.
So does anybody want to tell me why I should just give her a year? She hasn't done anything. I mean, not even paid towards HEB since 2018.
And so our request would be based on the medical issues, as well as the fact that she did seek gainful employment. We understand that this is not the way Ms. Tanahara should have handled this. She understands that.
State.
Judge, I did take into consideration the medical issues, which is why the state is asking for 2 years on this.
All right. Are you asking me to follow this revocation for 1 year?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, this is what the court will do. The court is finding violation of condition number 38 true. The court will grant the motion, revoke, sentence you to 1 year in the state jail facility, give you credit for any time served. There's to be restitution to HEB in the amount of $743.99. And that's under cause number 2017 CR 13698. There's to be no unsupervised contact with minors. And the court will request the therapeutic community for you. Therapeutic community doesn't increase the amount of time that you will serve, but it is designed to help you with any addictions you may suffer from.
On my way out of my room.
You know, during that the therapeutic community is in the state jail facility.
All right. Did you review the document entitled Trial Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. With your heart condition, if you continue to use, meth is not great for the heart to begin with, not even on a healthy heart. One or two things going to end up happening. Either you're going to be in and out of jail or in and out of prison for the rest of your life, or either you may get a bad batch, or it may hit your heart a certain way, and somebody's going to have to identify your body. If you're not going to be clean and healthy for yourself, then do it for your child if you love your child. And when you're released from the state jail facility, don't come to your sister's home acting like you've been the parent all the time and you're setting your own rules. You're going to need to flow with the way the household is set up. Do you understand?
Yes, ma'am.
All right. When you're released, if you cannot find a place to help you with your sobriety, any type of transitional home, if I'm still here, you come back here. I'll pick up the phone, call a place to help you. All right.
Appreciate that.
All right. Good luck to you. Okay.
Thank you.
You're welcome.
This hearing ultimately
Anyone
comes down to one core issue: accountability over time. The defendant was placed on community supervision back in 2017 for forgery, given structured opportunities through probation and felony drug court, and repeatedly instructed by the court to complete basic requirements, including parenting classes, participation in treatment programs, and payment of restitution. By the judge's own review of the record, virtually none of that was done after 2018. That matters because probation is not passive. It is conditional freedom, and every condition exists to show progress, responsibility, and stability. One of the most telling moments in this hearing is when the judge presses for specifics. When financial hardship is raised as an explanation, the court doesn't dismiss it outright, but instead asks precise follow-up questions. What fees? What program? When? The answers become vague, uncertain, and inconsistent. That's not just a credibility issue, it's a legal one. Courts rely on documented effort. Saying you struggled is not the same as showing what you did despite that struggle. And here, even the defendant ultimately admits she hasn't done anything toward the court's requirements. Medical issues, particularly congestive heart failure, are raised as mitigation, and they are taken seriously. Both the defense and the state acknowledge them, and the state explicitly notes that those issues are the reason it is not seeking the maximum 2-year sentence. That's important. It shows discretion, not indifference, but mitigation doesn't erase the record, it contextualizes it. The judge makes that balance clear. Health concerns may reduce punishment, but they do not excuse years of inaction, especially when there has already been a prior motion to revoke. The restitution issue is another critical factor. The amount $70.43.99 has been owed since 2018, and not a single payment has been made. From a legal standpoint, that's devastating. Restitution isn't symbolic, it's a direct obligation to make someone else whole. When a defendant hasn't paid anything over several years, it signals disengagement from the process entirely. That's why the judge repeatedly asks why she should impose a 1-year sentence instead of 2. The court isn't being punitive, it's asking for a reason grounded in effort. And there isn't one. Despite all of that, the final ruling reflects restraint. The judge follows the plea agreement, revokes probation, and sentences the defendant to 1 year in a state jail facility rather than the 2 years legally available. Credit for time served is applied. Restitution is ordered. Conditions are imposed regarding contact with minors, and notably, the court requests placement in a therapeutic community, an acknowledgement that addiction is a driving force here, and that treatment, not just confinement, is necessary. What truly stands out is the judge's closing remarks after going off the record. This isn't a lecture for the sake of authority, it's a warning rooted in reality. Continued methamphetamine use combined with a heart condition isn't just illegal, it's life-threatening. The judge lays out 2 futures plainly, a cycle of incarceration or a fatal outcome, and then she brings it back to the child, not as leverage but as responsibility. If the defendant can't choose sobriety for herself, she needs to choose it for her child. So here's the question for you. Did the court strike the right balance between compassion and accountability? Was 1 year appropriate given the lack of compliance, or should the full 2-year sentence have been imposed? And more broadly, how long should courts wait for effort before consequences become unavoidable? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.